My name is Vanessa Calloway. I am 34 years old. 6 months ago, my father slid a manila folder across a dining table that used to be mine to set and told me the family had made a decision without me in the room. The dining room still smelled like the pot roast my mother had made, the same recipe she'd made every important family dinner since I was a child. And I remember thinking, somewhere in the back of my mind, even as my father was talking, that she had chosen that smell on purpose, the same way she'd once chosen it for milestones she actually wanted me to feel included in. There was a candle burning near the center of the table, half melted down, the kind you light for an occasion, and I understood, watching my father slide that folder toward me past it, that this had been staged to feel like one. I did not raise my voice. I did not push the folder back. I opened it, read the first page twice, and closed it again, slowly, the way you close a door on a room you already know you are never walking back into. "You understand," my mother said, folding her napkin into a smaller and smaller square, "that you were never really, that legally, you're." She couldn't finish it. My sister finished it for her. "You're the adopted one, Nessa," Bianca said, not unkindly, the way you'd remind someone of a fact they'd simply forgotten, like a birthday or a dentist appointment. "There's nothing here for you. There was never going to be. Here is what none of them knew, sitting at that table, congratulating themselves on a clean, quiet betrayal." I had spent 11 years as a forensic accountant untangling other people's financial lies for a living, and I had learned exactly one thing above all others. Paper always outlives memory, and paper was about to become the only witness that mattered. 5 months later, I would be the one signing the closing documents on every property they thought they had taken from me. But that morning, at that table, all I did was pick up my coffee, take one sip, and ask a single question that made my father's hand shake around his fork. Whose name is actually on the loans? Welcome back to Calm Karma Stories, where ordinary people face impossible family moments and walk out with their dignity intact. If this is your first time here, this is exactly the kind of story we tell. Quiet, procedural justice, no shouting, no violence, just competence meeting consequence. Drop a comment telling me where you're watching from, and make sure you're subscribed, because what happens between that dinner and the 5 months that followed is going to make you want to watch it twice. But let me back up, because you can't understand what that folder meant, or why my question landed the way it did, until you understand who I actually was in that family, and who they had always quietly decided I wasn't. I run forensic accounting investigations for institutional clients, banks, insurers, occasionally a state regulator when a case gets ugly enough that they need someone who can read a loan file the way other people read a novel. I find the transaction that shouldn't exist. I find the signature that was added 6 months after the date on the page. It is unglamorous work. It is also work that makes you very, very hard to lie to with paperwork, which is an irony my family never once considered, even after 11 years of watching me do it for other people for a living. Let me give you one example from work, because it's the exact skill that ended up mattering most in my own family, and I think it's worth understanding before I go further. 2 years before any of this happened, I was brought in by a regional bank to investigate a small business owner who defaulted on a construction loan after claiming, in writing, that a flood had destroyed his equipment inventory. Everyone on the bank side wanted to write it off as bad luck and move on. I pulled the insurance claim filed on that same equipment 8 months earlier for a completely unrelated reason and found photographs, time-stamped, showing the exact same equipment sitting in a storage unit 2 counties away, fully intact, 3 weeks after the flood was supposed to have destroyed it. Nobody had lied to my face in that investigation. The truth had simply been sitting in a filing cabinet the whole time, waiting for someone patient enough to go looking for it. That is, essentially, my entire professional life in one story. And it would turn out to be my entire personal life as well, once my own family decided paper was something they could use against me without expecting me to read it back. I have one habit that has never changed since I was 19 years old. Before I open any file I know is going to matter. A case, a contract, a bad diagnosis, a bad dinner. I order an Americano, extra shot, black, no matter what time of day it is, and I tap a mechanical pencil against the table 3 times before I start. My grandfather gave me that pencil the year I turned 12. It still has his initials scratched into the barrel. It is the only object from that family I have ever let myself get sentimental about, and it was sitting in my blazer pocket the entire time my mother tried to explain to me why I didn't belong to them anymore. I was adopted at 3 years old. My parents, Richard and Diane Calloway, took me in during a stretch of their lives when they wanted a second child, and my birth mother could not keep one. 2 years later, against what their doctors had told them was a near impossibility, Diane got pregnant. Bianca was born when I was 5. And from that day forward, without either of them ever saying it out loud in so many words, our house ran on an unspoken ledger that everyone could read, except, apparently, me. The one who was supposed to be grateful for a place at the table, and the one who was simply owed it. I want to be precise here, because precision is the entire point of this story. My parents were not cruel to me as a child. They were, in most visible ways, fine. I had clothes, a bedroom, birthday parties, a spot in the family photos. What I did not have, from somewhere around age 11 onward, was ever being treated as a full owner of anything that belonged to the family. Bianca got the good china set aside for her someday. I got told, gently, that I should be flexible, since I'd understand better than she would what it meant to build something from nothing. My father used to say it at least 3 separate ways a year, usually at holidays, usually with a drink in his hand and a smile that made it sound like wisdom instead of what it actually was. Blood decides who really carries this family forward. He said it the year I graduated top of my accounting class and Bianca dropped out of her second community college program. He said it the year I paid off my parents' HVAC replacement out of my own signing bonus because Bianca had spent what was supposed to be the emergency fund on a trip to Cabo. He said it again, almost word for word, at my grandfather's funeral, standing over the same man whose pencil I still carry, as if blood were the only inheritance that had ever mattered in that family, and paperwork, deeds, mortgages, promissory notes, the actual instruments of ownership, were just details other people handled. I let him say it every time. I filed it away every time. That was always my real skill, long before I had a CPA license to make it official. I do not fight people in the room where they insult me. I fight them in the room where the deed is recorded. By the time I was 26, my parents had built a modest real estate portfolio. 4 rental duplexes on the east side of the city, the family's lake cabin at Cedar Hollow, and the primary residence I grew up in, all told worth somewhere north of $2 million on paper. What almost nobody in that family understood, because almost nobody in that family ever asked, was how that portfolio actually functioned. My father had bought most of it using commercial balloon note financing in the early 2010s, loans that carry low payments for years and then demand the entire remaining balance in one lump sum on a fixed date. He had refinanced twice since then. Both times, because his own credit had taken hits from 2 failed side businesses, the bank had required a qualified cosigner with strong income and a clean financial history to get the refinance approved. Both times, that cosigner was me. I want you to sit with that for a second, because it's the detail this entire story pivots on. I was not simply the family's emotional fixer, the responsible daughter who showed up and smoothed things over. I was, quite literally, load-bearing. My name was on paperwork tied to properties that my parents' own estate plan would later claim had nothing to do with me. I had also, over 11 years, personally lent my parents $214,000 across 6 separate transfers. Never a gift, always structured as a loan, always with a signed promissory note, because that is simply how I am built. I do not hand money to family members without documentation, not out of distrust exactly, but out of the same instinct that makes a surgeon wash her hands twice. It isn't personal. It's procedure. Bianca, meanwhile, had never signed anything. Bianca had never been asked to. Bianca had grown up being told, in 100 small ways, that she was the one the family's future actually belonged to, and so she had never developed the muscle for handling money that came with real obligations attached. By the time she was 31, she had run through 2 small businesses, defaulted on a car loan our parents quietly covered, and was, at the time of that dinner, 4 months behind on the mortgage of her own condo. Something none of us were supposed to know, and something I only knew because I am, professionally, extremely good at finding out things people don't want found. Let me give you 3 small scenes, because a family pattern like ours never announces itself in one single moment. It builds, quietly, across 100 small ones, until one day you look back and realize the shape it was always making. The first scene. I was 12. Bianca was 7. Our grandfather. My mother's father. The one who gave me the pencil I still carry. had passed away that spring, and the family gathered to divide up a small collection of his tools and keepsakes. There wasn't much: a pocket watch, a set of hand-carved chess pieces, that mechanical pencil. My mother handed the pocket watch and the chess set to Bianca to hold on to for when she's older, and handed me the pencil, almost as an afterthought, saying, "Here, you always liked writing things down anyway." I didn't understand until years later that even in that moment, the family was quietly sorting which of us got to be an heir and which of us got to be useful. The second scene. I was 17, filling out early financial aid paperwork for college, sitting at the kitchen table with my father looking over my shoulder. He read the question about household assets, laughed a little, and said, "Put down whatever you want here. This stuff was never really going to be yours anyway, so it's not really lying." I remember writing 0 in that box and feeling, for the first time, that the number wasn't just about financial aid. It was about how he actually saw the math of our family. The third scene came later, the year I turned 28, the year I'd already quietly co-signed my parents' first refinance without a single word of thanks beyond, "You're good with this stuff, aren't you?" And Bianca announced at Thanksgiving that she and her then boyfriend were probably going to end up at the lake house eventually, once mom and dad are ready to pass things down. Nobody at that table corrected her. Nobody looked at me. I remember refilling my water glass very slowly, the way you do when you need your hands to have something to do besides show what your face is doing. 3 scenes, 21 years apart from first to last, same shape every time. I want you to notice that shape, because it's the same shape almost every family like ours takes. Not one cruel moment, but 1,000 small quiet ones, each easy enough to forgive on its own, until you add them up and realize you've been handed the invoice your entire life without ever once being handed the deed. The inciting event, the moment the quiet architecture of my family's favoritism turned into an active plan to erase me, started roughly 14 months before that dinner with a phone call I wasn't supposed to overhear. I had stopped by my parents' house to drop off tax documents for the rental portfolio, something I still did every March out of habit and, if I'm honest, out of the small, stubborn hope that being useful might eventually be treated as the same thing as being wanted. My mother's home office door was open a few inches. She was on the phone with a name I recognized. Everett Doss, an estate attorney my parents had started seeing without ever mentioning it to me. "She'll understand," my mother was saying. "She's practical. She'll see it as fair, given everything." There was a pause. Then, "No, we don't need to explain the adoption part in the document itself, do we? We just need the trust to name Bianca as sole beneficiary and leave it at that." I did not walk in. I did not confront her in that hallway, standing in my coat with tax folders under my arm like some kind of ambush. I went home, and I did what I have always done instead of crying in front of people who have already decided I don't deserve their tears. I opened a blank spreadsheet, and I started building a file. I want to tell you what that actually looked like, because I think people imagine forensic accountants building some dramatic secret dossier, and the truth is much quieter than that. I made 4 tabs. The first, a running timeline of every conversation, dated, with as close to exact wording as I could remember, because memory degrades and dates don't. The second, a list of every dollar I had ever transferred to my parents, cross-referenced against the promissory notes I already had signed copies of in a fireproof box in my closet. The third, a list of every piece of paperwork with my name on it tied to the family's properties, guarantor agreements, insurance policies I'd been added to as a named party for liability reasons, property tax filings that listed me as a point of contact. The 4th tab I left blank for a long time, labeled simply, "If this becomes something." Because even then, 14 months before any of it mattered, some instinct in me already understood that a family capable of planning something like this quietly for years was not a family that would stop at simply being quiet about it. That 4th tab filled up faster than I expected it to. 2 weeks later, I quietly requested, through entirely legal public record channels, the same way I'd pull records for any client, copies of the recorded liens on all 4 rental duplexes. I already had my name on the refinance guarantees. What I confirmed, sitting at my kitchen table with my Americano going cold beside my grandfather's pencil, was that both refinances explicitly listed me as a guarantor with a contractual right to be notified of any transfer of the underlying properties, and that my $214,000 in loans to my parents were secured, per the promissory notes I'd insisted on years earlier, against the equity in the Cedar Hollow cabin specifically. My parents had spent a decade building a legal structure where they could not actually give those properties away clean. They just didn't know it because they had never once, in 14 years, asked me a single question about how the paperwork worked. They had simply assumed that because my name wasn't on the emotional ledger, it also wasn't on the legal one. They were wrong on both counts. They just hadn't found out yet. 3 months after that overheard phone call, my mother invited me to what she called a family conversation about the future. I said yes. Of course I said yes. I ordered my Americano that morning exactly the way I always do, tapped my grandfather's pencil 3 times against my kitchen counter, and drove to my childhood home already knowing, in broad strokes, what was coming, but not yet knowing exactly how they intended to deliver it. What I did not expect was the folder. My father had it printed and bound at a copy shop, tabbed with little colored dividers like it was a corporate presentation instead of a decision to erase his adopted daughter from a family's future. He slid it across the table the way you'd slide over a menu. Inside was a summary of a revocable living trust, recently executed with attorney Everett Doss, naming Bianca Calloway as sole beneficiary of the entire estate. The primary residence, all 4 rental duplexes, and the Cedar Hollow cabin. My name did not appear once. Not as trustee. Not as contingent beneficiary. Not as a footnote. We wanted to do this properly, my father said. Get it on paper. No confusion later. That's the part that's hard to admit, even now, months later, with everything resolved exactly the way it eventually got resolved. For about 4 seconds, sitting at that table, I felt 11 years old again, the year I first understood that some kind of invisible line existed in my own house that I would never fully be allowed to cross. It's a strange kind of grief, being told with total calm, over dessert, that you were never actually anyone's daughter in the way that counts. Then my training took over. Because underneath grief, if you've spent your whole career reading documents for a living, there is always a second reaction running in parallel. What does this paper actually say, and what does it not say? And what this trust did not say. What my father, in his triumph, had apparently not thought to ask his own attorney was how a trust interacts with existing recorded liens, existing loan guarantor agreements, and existing secured promissory notes that predate the trust by years. I did not explain any of that at the table. I did not raise my voice, did not cry, did not do any of the things that would have let them file this moment away as Nessa got emotional instead of what it actually was, which was the exact moment I stopped being willing to subsidize a family that had just formally notarized in writing, told me I didn't belong to it. I asked one question. Whose name is actually on the loans? My father blinked. What loans? The refinances, I said. On the duplexes, 2019 and 2021. He looked at my mother. My mother looked at Bianca. Bianca looked at her phone because at that point in her life, difficult silences were something she had learned to wait out rather than sit inside of. That's not really relevant to tonight, my mother said carefully. It's extremely relevant, I said, and I want you to notice, because this matters for the entire rest of this story, that my voice did not rise even a single register when I said it. Because my name is on both of those refinance guarantees, and because I hold recorded liens against the Cedar Hollow cabin specifically, securing $214,000 in loans that were never gifts. They were loans with signed notes, and they are legally enforceable regardless of what any trust says about who owns the property on paper. The silence that followed lasted 11 full seconds. I counted them the way I count everything, out of habit, and because counting keeps my own hands steady. You're bluffing, Bianca said finally, not looking up from her phone. I don't bluff, I said. It's not really compatible with my job. I finished my coffee. I did not raise my voice again that entire evening. I thanked my mother for dinner, the way you do, out of some deeply ingrained reflex that outlives the relationships it was built for, and I drove home. I want to pause here, because I know some of you are already anticipating a screaming match, a slammed door, a dramatic scene where I finally tell them everything I'd been holding back for 30 years. That is not what this story is. That has never been what this channel is about. I did not go home in rage. I went home, made a second Americano because I was going to be up late, and opened the same spreadsheet I'd started 14 months earlier, and I began building the file that would eventually let me buy back, cleanly, legally, with my own name on the closing documents, every single thing they had just told me I would never own. Now let me bring you forward to what happened in the 5 months that followed, because this is where the trap they thought they'd built started, very quietly, closing around them instead. Here is what my father did not know when he handed me that bound folder. Bianca's condo mortgage was, at that exact moment, 91 days delinquent. Her lender had already sent 2 formal notices of default. In most states, once a mortgage crosses the 90-day threshold, the lender has the legal right to accelerate foreclosure proceedings and Bianca's lender. I would learn later, through entirely public court filing records, the same kind I pull for clients every week, had done exactly that 11 days after our family dinner. Here is what my mother did not know. The Cedar Hollow cabin's original 2021 refinance was structured as a 5-year balloon note. That balloon payment, the full remaining principal, over $340,000, was due in full in exactly 90 days from the night of that dinner. My father had, apparently, been planning to have Bianca simply take over the cabin's mortgage payments once the trust made her the owner, without ever checking with the lender about whether a beneficiary transfer through a revocable trust even satisfied the loan's due on transfer clause, or whether Bianca's credit history, thin and now actively damaged by her own condo default, would qualify her for any refinance at all. It would not. I knew that before he did, because I had pulled her credit disclosures the same legal way I pull everyone's, the moment I started building my file. Here is the ticking clock, and I want to say it plainly, because the next 90 days are the whole spine of what happened. My parents had 90 days to either pay off the Cedar Hollow balloon note in full or refinance it before the bank moved to foreclose on the one property in that trust I actually held a recorded lien against. And they had handed the entire portfolio, on paper, to a beneficiary who could not personally qualify for a single dollar of the refinancing that portfolio actually required to survive. I did not create that trap. I want to be completely clear about that because it matters to the moral of this story. I did not manipulate any loan terms, did not call any bank to accelerate anything, did not do a single thing to Bianca's condo or my parents' balloon note. All of that was already sitting there. In paper, my family had signed years before they ever decided to write me out of anything. All I did, for 90 days, was wait, calmly, with my grandfather's pencil in my blazer pocket, and keep building my file. 6 weeks into that 90-day window, I found the document that changed this from a story about bad luck into a story about premeditation. I want to tell you exactly how I found it, because it's the discovery beat of this whole story, and it's the moment I stopped feeling any guilt at all about what I eventually did. Part of closing out my role as guarantor on the 2 rental duplex refinances required me to formally request, through the title company that had handled both closings, a full copy of my guarantor file. Standard practice, something any co-signer is entitled to request. Buried in that file, forwarded to the title company as part of the most recent refinance packet, was a string of email correspondence between my father and attorney Everett Doss, dated nearly 2 years before that dinner, long before the overheard phone call, long before any conversation with me at all. In one email, dated a full 22 months earlier, my father wrote, and I am summarizing rather than quoting it directly because some things don't need exact wording to land. He asked Doss whether a trust could be structured to exclude an adopted child entirely, regardless of any financial contributions she had made to the estate, and whether such an exclusion could survive a legal challenge if she ever tried to claim an equitable interest based on those contributions. Doss's reply, also in that file, laid out. Again, I'm summarizing, not quoting. That yes, a trust could exclude her, but that any existing liens, guarantor agreements, or secured loans she held against specific properties would remain fully enforceable regardless of what the trust document said, and that if she held recorded security interests, buying her out cleanly might ultimately be cheaper and safer than trying to litigate around her claims. 22 months. My father had been planning to write me out of that family's future for nearly 2 years before he ever slid that folder across the table, and his own attorney had told him, in writing, that the cleanest way to actually do it would eventually be to buy me off, not the other way around. I want to walk you through exactly what was sitting in that guarantor file, because this is the part of the story that turned a bad night into an actual case, and I built it the same methodical way I build every file for a client. 4 documents. I labeled them the way I label everything, in order, dated, cross-referenced. Document 1. The original 2019 refinance guarantee agreement on the 2 East Side duplexes, bearing my signature as guarantor and a clause. Standard and commercial guarantor agreements, the kind almost nobody reads past the signature line, granting the guarantor formal notification rights and first right of refusal in the event of borrower default or property transfer. Document 2. The 2021 refinance on the remaining 2 duplexes and the Cedar Hollow balloon note, structurally identical, same clause, same rights, my signature again. Document 3. 6 promissory notes, spanning 11 years, totaling $214,000, each one specifying the loan was secured against equity in the Cedar Hollow cabin specifically, each one signed by both my parents, each one notarized because I have never in my life handed anyone money without a notary in the room, family or otherwise. Document 4. The email chain. 22 months old. My father asking his attorney whether an adopted child could be excluded from a trust regardless of her financial contributions. The attorney's reply, laying out, calmly, in writing, that any existing liens or guarantor rights she held would survive the trust entirely, and that buying her out might ultimately be the cheaper option. 4 documents. 11 years, in some cases, of paper trail. And every single one of them had been sitting quietly in filing cabinets and title company archives the entire time my family sat around a table and told me there was nothing there for me. I sat with that 4th document open on my laptop for a long time, longer than I usually let myself sit with anything. Then I did what I do with every piece of evidence I've ever handled in 11 years of this work. I saved it 3 separate ways, dated it, and moved on to the next document. Somewhere in the middle of that 90-day window, before I'd found the email, before any of the bank denials had landed, Bianca called me directly for the first time in months. Not about the trust. About nothing in particular, actually. She wanted to know if I still had our grandfather's old chess set, the one my mother had handed her at 12 years old, and that Bianca, by her own admission, had never once taken out of its box. I told her I didn't, that it had been hers all along, sitting somewhere in a closet at our parents' house. There was a long pause on the line. I don't think I ever actually wanted any of this stuff, she said, quietly. I think I just wanted to be the one people assumed would get it. That's different, isn't it? I remember sitting with that sentence for a long time after we hung up, because it was the first honest thing either of us had said to each other in years, and because some part of me understood, even then, that whatever was coming in the next few weeks was never really a war between the two of us. We were both, in our own ways, cast in roles neither of us had fully chosen. She, the assumed heir who'd never been taught what an inheritance actually costs to maintain, and me, the assumed outsider who'd been taught that maintaining things was the only value I'd ever be allowed to have. Stay with me here, because what happens over the next 6 weeks is the part people always ask me to slow down and repeat. So let me say it once, clearly, and then walk you through it. If you haven't already, subscribe now, because the confrontation that's coming is the part of this story people quote back to me the most. With the balloon note deadline closing in, my father tried, quietly, to refinance the Cedar Hollow cabin under Bianca's name through the same regional bank that had held the original loan. The bank's underwriting department, following the same due-on-transfer clause that governs almost every commercial real estate loan in this country, flagged the trust transfer immediately and required a formal reapplication under the new titled owner. Bianca's application was denied in 11 business days. Insufficient income, an active mortgage default on her own condo, and a debt-to-income ratio that made the bank's underwriter. According to the denial letter, my father later showed my mother in a conversation I was not in the room for, but eventually learned about in full, not comfortable extending further commercial credit at this time. My father tried a second lender. Same result, faster this time, because Bianca's condo foreclosure filing had, by then, become a matter of public record, searchable by any underwriter running a basic credit and litigation check. I should tell you what those 2 denial letters actually looked like, because I eventually held copies of both, and there is something almost clinical about how plainly a bank will tell you no. The first, from the regional lender that had held the original note, ran 4 paragraphs and cited, specifically, an insufficient debt service coverage ratio given the applicant's existing consumer debt obligations, including an active mortgage delinquency of record. The second, from a smaller commercial lender my father approached out of what I can only describe as desperation, was shorter. 2 paragraphs. It cited the same delinquency, plus a newly filed notice of foreclosure that had, by then, posted to the county recorder's office, and become instantly visible to any underwriter running a standard title search. My mother, I later learned from a conversation Bianca and I had months afterward, spent an entire weekend trying to reach a private wealth manager a neighbor had once mentioned at a block party, hoping there was some financial instrument, some quiet workaround that could make Bianca's application look stronger on paper than it actually was. There wasn't. There rarely is once a default has already posted publicly. That is, in fact, the entire design of the system. It exists specifically so that paper, once filed, cannot simply be talked around by whoever is most charming in the room. My family had spent 30 years operating on charm, on unspoken rules, on who was allowed to feel entitled to what. The banking system does not run on any of that. It runs on debt-to-income ratios and recorded liens. And for the first time in my life, that made it the one system in my family's orbit that was actually, finally, fair to me. With 60 days left on the balloon note, my father called me. I let it go to voicemail, not out of spite, out of procedure. I do not take calls about active financial disputes without a paper trail, and a voicemail is a paper trail. He left one anyway. Nessa, it's Dad. Look, there's been some. The bank's being difficult about the cabin refinance. We might need to talk about restructuring things. Call me back. I called him back 2 days later, at 10 in the morning, from my office, on a line I record for professional reasons, and disclosed to him at the start of the call, exactly as I would with any client. I understand there's a balloon payment coming due on Cedar Hollow, I said. There's a solution here, my father said, and I could hear, even through the phone, that he had rehearsed this. We were thinking the trust could be amended, bring you back in as a co-trustee, give you a piece of the cabin specifically, since you're the one with the lien anyway. It only makes sense. Here is the line I want you to remember, because it's the one moment in this entire story where I let myself say, out loud, exactly what I had been carrying since I was 11 years old. Dad, I said, you didn't call me because I'm your daughter. You called me because I'm the only person in this family who can actually read a loan document. Those aren't the same thing, and you taught me that yourself, every year at Thanksgiving, when you told everyone blood decides who carries this family forward. Well, here's what the blood actually decided. It decided I'd be the one holding all the paper. He didn't have an answer for that. There wasn't one that didn't require him to admit something he'd spent 30 years refusing to admit. I want to describe the drive home from that phone call because it's one of the only moments in this entire story where I let myself feel the full weight of what was actually happening, rather than just processing it as a case. I pulled into a gas station parking lot 2 miles from my house, put the car in park, and sat there for almost 20 minutes without turning the engine off, watching the fuel gauge needle not move, thinking about a 12-year-old girl who'd been handed a pencil instead of a pocket watch and told herself for 22 years that it didn't mean anything. It meant something. It had always meant something. I just hadn't been ready, until that phone call, to admit how much. Then I drove home, made myself dinner, and went back to my file. Because grief, in my experience, is something you're allowed to feel completely and still keep working through at the same time. Those two things have never been contradictory for me. I think that's actually the whole reason I survived this family as well as I did. I did not restructure the trust. I did not agree to be added back in as a favor, on their timeline, on their terms, after they'd already shown me in writing what they actually thought I was worth. Instead, I did what I had been quietly preparing to do since the night of that dinner. I contacted the bank directly, in writing, in my capacity as an existing guarantor with a recorded lien on the property, and formally exercised my contractual right. Buried in the original refinance guarantee language my father had signed and never fully read 11 years earlier. To be offered first opportunity to purchase the property in the event the borrower could not satisfy the loan's terms. That right existed. It had always existed. Nobody had ever needed it before, because nobody had ever tried to cut me out before. With 30 days left on the clock, the bank confirmed in writing that the trust, unable to refinance under Bianca's name and unable to produce the full balloon payment, was in default on the Cedar Hollow note. As the existing guarantor and lien holder, I was formally offered the right to satisfy the loan and take title, provided I could show proof of funds within the remaining window. I could. I had spent 11 years building exactly the kind of financial profile that makes a bank say yes in 11 days instead of 11 weeks. I want to be honest with you about something here, because I think it matters. I did not do this out of revenge. I want that understood clearly, because I know it would be easy to tell this story as one long, satisfying act of payback, and that is not how it actually felt from inside it. I did this because it was, quite simply, the only remaining option that protected the $214 00I was legally owed, protected the equity I had personally guaranteed for over a decade, and did not require me to beg a family that had already told me, in a bound folder with color-coded tabs, exactly how much I counted. 22 days before the deadline, I sat down with my own attorney, not Everett Doss, a different firm entirely, one that has represented me for years on unrelated matters, and we structured a clean, fully documented purchase agreement. I would satisfy the Cedar Hollow balloon note in full, taking title to the cabin outright in partial settlement of the $214,000 owed to me. The remaining balance of that debt, still secured by the promissory notes, would convert into a formal claim against the trust's other assets, the 4 rental duplexes and the family home, payable either in cash or, if the trust preferred, in additional property. We wrote it out in 5 clear terms, because I have never once in my career trusted a verbal understanding to survive contact with a family that had already shown me exactly how flexible their memory could be when it was convenient. Term 1, I would pay the Cedar Hollow balloon note in full, roughly $340,000, directly to the lender, receiving clear title to the cabin in return. Term 2, that payment would be credited first against the $214,000 the trust already owed me, meaning the trust, in a strange twist neither of my parents saw coming, would actually owe me the difference once the cabin's value exceeded the outstanding debt. Term 3, any remaining claim I held would be satisfied through additional property rather than cash, since the trust had no meaningful liquidity left. Term 4, all transfers would be appraised by a neutral third-party appraiser agreed to by both sides, so that no one, ever, could later claim I'd taken advantage of the family's desperation to buy property under value. And Term 5, every signature on every document would be notarized, dated, and copied 3 ways, the same way I have handled every important piece of paper in my life since I was old enough to sign one. I insisted on that third-party appraisal clause specifically because I wanted there to be no future version of this story where anyone could credibly claim I'd exploited my family's crisis for a discount. I paid fair value for every square foot I ended up owning. That mattered to me more than almost anything else in the entire process, because the entire point of what I was doing was proving that competence, applied honestly, doesn't need to cut corners to win. The trust could not pay it in cash. Bianca had no income to speak of by that point, her condo already moving through foreclosure. My parents' liquid savings had been drawn down over the prior year, covering Bianca's mounting defaults, something I only fully understood once my attorney and I pulled a complete accounting of the trust's actual financial position as part of settling my claim, which meant the only asset left to satisfy the remaining $140,000 I was still owed was equity in the rental duplexes themselves. 14 days before the deadline, my father asked for one final meeting. Not at the house this time. At Everett Doss's office, with Doss present, with Bianca present, with my mother sitting between them like a woman watching a car she was driving slide slowly toward a wall she had built herself. I brought my own attorney. I brought my file. 3 years in the making by that point, though it had only formally started 14 months earlier. I brought my grandfather's pencil, though nobody in that room but me would ever know why that mattered. The office was smaller than I expected for a man who'd spent 2 years quietly architecting my exit from a family estate. A single window overlooking a parking garage. A framed law degree. A conference table just barely large enough for the 6 of us, my attorney and me on one side, Doss and my parents and Bianca arranged across from us like the losing side of a negotiation that hadn't technically started yet, though everyone in that room already understood, on some level, how it was going to end. Doss opened with the kind of practiced calm you'd expect from a man whose entire profession depends on sounding reasonable, even when the facts in front of him are not going his way. He talked about finding a path forward that honors everyone's interests. He used the word family 4 times in his first 2 minutes, which I noted, out of habit, the same way I note every recurring word in every negotiation I've ever sat through, because repetition is usually a tell for exactly the thing a person is most afraid the room will forget. My attorney let him finish. Then she placed, in front of Doss, a single-page summary. 1 page, because the best evidence in any negotiation is the version that requires the least explanation. showing the trust's current liabilities against its current liquid assets. The math was not complicated. The trust owed me $140,000 it could not pay in cash. It held equity almost entirely in 4 rental properties. There was no third option in that room, no clever restructuring, no amount of Doss's careful language about family and honoring interests that could conjure liquidity that did not exist. My father tried anyway. "We never meant for it to go this far," he said. "This was always supposed to stay in the family." "It did stay in the family," I said. "You just decided which member of the family it was allowed to stay with?" "I'm simply making sure it's accurate." Doss, to his credit, did not try to argue the paper. He had, after all, written the very email that told my father this exact outcome was likely 2 years before it happened. He walked my father through what my attorney had already confirmed in writing. The trust owed me $140,000 it could not pay in cash, secured against equity that existed almost entirely in the 4 rental duplexes, and I held documented first right of refusal on any property sale required to satisfy that debt. Bianca, for the first time in this entire 5-month story, spoke directly to me instead of about me. "You planned this," she said, not screaming, just flat and tired. The way people sound when they finally understand a game they didn't know they were playing. "I didn't plan any of it," I said. "And this is the part I need you to hear clearly, because it's the actual center of this entire story. I didn't create the balloon note. I didn't default on your condo. I didn't write the email your father sent Everett Doss 22 months ago asking whether he could exclude me and still keep the family's assets intact. All I did, Bianca, was refuse to disappear quietly when everyone in this room decided that's what I was supposed to do. Everything else was already written down. I just read it." I watched something shift in her face when I said the part about the email. She looked at our father. He did not look back at her. "You've had this planned for 2 years?" she asked him, and for the first time in this entire story, the betrayal in the room wasn't pointed at me at all. He didn't answer. He didn't have to. The date on that email did the answering for him. My mother, who had said almost nothing since the meeting began, finally spoke, and her voice had none of the composure she'd walked in with. "Richard," she said, "just his name, quiet, the way you say a name when you're realizing you've been standing next to a stranger for longer than you knew." Doss shifted a folder on the table in front of him, the kind of small physical gesture lawyers make when they want the room to remember they are, technically, only there to advise, not to be implicated in what their advice produced. My father stared at the email printout my attorney had placed on the table, at his own name at the top of it, at a sentence he had apparently forgotten he'd ever typed, and said nothing at all. There was no yelling in that room. There never is in the moments that actually matter. There was just the sound of 4 adults sitting with a piece of paper that had just publicly, undeniably, told on all of them. By the time we left Doss's office that afternoon, the plan my parents had spent 2 years building. Quietly, on paper, believing paper was the one thing I'd never fully understand how to use against them, had failed in the one room where it actually needed to hold together. Not because I raised my voice, not because I threatened anyone, because the math simply did not work without me, and the paper trail proved it had never been designed to. In front of Doss, in front of my mother, in front of Bianca, the plan they had built 5 months earlier. Quietly, cleanly, on paper, believing paper was the one thing I would never fully understand how to use against them, collapsed under the weight of paper that predated all of it. The trust could not pay its debt to me in cash. It had no other option but to satisfy that debt in property. And I was the only party in that room, or in that entire extended family, with the qualified financial standing, the existing lien position, and the documented right of first refusal to take that property cleanly at fair market value through an entirely legal, entirely public closing process. 2 of the 4 rental duplexes transferred to me in full satisfaction of the remaining debt, appraised and priced by an independent third party neither side selected, exactly the way my attorney had structured it to avoid any future claim of unfairness. 3 weeks after that meeting, with Bianca's condo foreclosure finalizing and no income to maintain even her half of the remaining 2 duplexes, she came to me directly, not through my parents, not through Doss, directly, and asked whether I'd buy out her share of those as well, at fair value, so she could walk away with something instead of nothing once the foreclosure fully wiped out her credit. She showed up at my office unannounced, which she'd never done before, and sat across from me in the same kind of small conference room where I usually deliver bad news to strangers for a living. "I know I don't have any right to ask you for anything," she said, "but you're the only person left in this whole mess who actually knows what these properties are worth, and I trust your number more than I'd trust anyone else's." That sentence stayed with me longer than almost anything else in this entire story, because it was, in its own strange way, the first time in 30 years anyone in that family had told me directly that my competence was something they respected rather than simply something they used. I said yes. I did not negotiate her down out of spite. I paid the appraised value, in full, through a standard closing, with my own attorney reviewing every page, and I made sure Bianca had her own separate legal counsel review it too, at my expense, specifically so that no one could ever say I'd taken advantage of her while she was down. I wanted her walking out of that closing with money in her account and a clean signature on a fair deal, not a debt of gratitude she'd spend years resenting. 5 months, almost to the day, after my father slid that bound folder across a dining table and told me there was nothing in that family's future for me, I held clear title to all 4 rental duplexes and the Cedar Hollow cabin. The only property remaining in the original trust was the family home itself, still legally Bianca's on paper, though by then everyone in that family understood exactly whose competence had built the paper trail that decided who actually ended up owning anything real. The aftermath cascaded exactly the way these things do once the paperwork finishes doing its work. Bianca's condo foreclosure closed out fully within 6 weeks, and she moved into a small rental across town. The first lease she had ever signed entirely in her own name, with her own credit, without a co-signer standing behind her. My father, humiliated in front of his own attorney, stopped attending the monthly poker game he'd hosted for 11 years with 3 old business friends, one of whom, it turned out, had heard the whole story secondhand from Doss's office manager and mentioned it, gently, at the following month's game. My mother called me twice in the 2 months after that final meeting. I let both calls go to voicemail, the same way I'd let my father's call go to voicemail 5 months earlier, and for the same reason. Some conversations deserve a paper trail before they deserve a live response. Week 1, after the closings finalized, my father tried reaching out through a mutual family friend, a woman named Carol, who had known my mother since college, asking her to have a word with Nessa, see if she'll soften a little. Carol called me directly instead of relaying the message secondhand, told me exactly what he'd asked, and said she wasn't interested in being anyone's messenger in a conversation that clearly needed to happen between the actual people involved. I appreciated that more than I let on at the time. Week 3, Bianca reached out on her own, not through anyone, just a short message asking if we could get coffee. No agenda, no lawyers, just the 2 of us. We did. I ordered my usual. She ordered a decaf latte and stared at it for a long time before she finally said the thing I think she'd been carrying since that meeting at Doss's office. "I didn't know he'd been planning it for 2 years, she said. I thought it was just how things had always been. I didn't know someone had to sit down and decide it. I told her I believed her, because I did, and because there is a real difference between inheriting a family's favoritism passively, the way Bianca had her whole life, and actively engineering it, the way our father had. That distinction mattered to me. It's the entire reason our relationship survived this and theirs, for a long while, did not. Month 2, my father attempted one more maneuver. A request, through Doss, to have the original trust amended retroactively to reflect what he called a more balanced original intent, a phrasing that both my attorney and I recognized immediately as an attempt to quietly rewrite the 22-month-old email out of relevance after the fact. It went nowhere. You cannot retroactively unplan something that was already put in writing and time-stamped by your own attorney's server. Paper does not forget, even when people very badly want it to. Month 4, my mother finally stopped calling and started writing letters instead. Actual paper, actual stamps, which I suspect she chose deliberately, having finally understood, 5 months too late, that paper was the language I had always been fluent in, and she had spent 30 years assuming I only used it out of some cold personality quirk rather than because it was the one form of communication. In that family, that couldn't later be denied. I did eventually call her back. 3 months after the closings finalized, once every document was signed, every duplex reassigned, every lien satisfied and released, I called my mother on a Sunday afternoon and told her I would be willing to have a conversation on 3 conditions, all of which I stated plainly and none of which I was willing to negotiate. I want to be clear about why I insisted on these particular 3 conditions, because I think it matters for anyone listening who's ever had to rebuild a relationship with someone who hurt them badly enough that the old version of the relationship simply isn't available anymore. I wasn't trying to punish my mother. I was trying to make sure that whatever came next was built on something sturdier than the unspoken assumptions that had gotten us here in the first place. A family that operates entirely on feeling and memory, and who's owed what based on vibes, is a family where the person with the least power in the room is always the most vulnerable to being quietly rewritten out of the story. I had spent 30 years being that person. I was not going to spend the next 30 being her again, reconciliation or not. First, any future family conversation involving money, property, or estate matters would happen with both our attorneys present, permanently, going forward. No exceptions. Second, my mother would need to say the actual sentence out loud, not around it, not near it, but directly, that they had spent 2 years planning to exclude me from that family's assets specifically because I was adopted, and that this plan, not any single argument or disagreement, was what had ended our relationship as it used to exist. Third, I would not be attending holidays at that house again. If she wanted a relationship with me, it would happen on neutral ground, on my schedule, indefinitely. She agreed to all 3. It took her nearly 4 minutes to say the actual sentence out loud, and her voice broke twice trying. I did not fill that silence for her. I let her sit inside it, the same way I'd sat inside 11 seconds of silence at that dinner table 5 months earlier, because some silences are owed, and it isn't kindness to rescue someone from a silence they built themselves. We met 3 weeks later at a small coffee shop halfway between our 2 neighborhoods, neither of our houses, exactly the kind of neutral ground I'd specified. She showed up 10 minutes early, which she never used to do, and she'd brought, of all things, that same handwritten list she'd once shown up at my door with. Except this time, when she slid it across the table, it wasn't a list of what the family needed from me. It was a list of dates, apologies she wanted to make sure she covered, written out in advance because she said she was afraid that if she didn't write them down, she'd lose her nerve halfway through and soften them the way she'd softened every hard conversation in that family for 30 years. "I used to think you were just naturally cold," she said, reading almost directly off the list. I told people that. I told your sister that when she was younger, that you'd just always been the practical one, like it was a personality trait, instead of something we built into you by never once making you feel like you belonged without earning it first. I didn't correct her framing, though I could have. I let her get through the list. When she finished, she asked me one question that I think mattered more to her than anything else she'd said. "Do you think we can ever get back to something normal?" "I think we can get to something honest," I told her. "I'm not sure that was ever the same thing as normal, in this family. I'd rather have honest." She nodded, slowly, and I noticed she didn't argue with that the way the old version of her would have. That, more than the apology itself, was the thing that told me something had actually shifted. I drove past the Cedar Hollow cabin about a month after the closing finalized, the first time I'd been back since I was a teenager. The dock was still crooked the way it had always been, the one my father promised for a decade he'd fix and never did. I sat on the porch steps for a while, alone, holding a coffee that had gone cold, and I thought about how strange it was that the thing my family had once told me could never be mine was now, on paper and in fact, entirely mine, secured by the exact same signatures they'd once assumed would only ever protect them. I didn't feel triumphant sitting there. I felt mostly tired and quietly certain, for the first time in years, that I was finally standing on ground nobody could tell me I didn't belong to. My relationship with my parents today is smaller than it used to be, and considerably more honest. We see each other perhaps 6 times a year, always somewhere neutral, always without ambush, always with the explicit understanding that competence, not blood, is what actually earned my seat at any table going forward. My relationship with Bianca is, unexpectedly, the one that healed fastest and most completely, because she was the only person in that story who was also, in her own way, a casualty of a family myth that had told both of us different lies our entire lives. Her, that she'd always be provided for regardless of what she built. And me, that nothing I built would ever quite count as mine. She rents one of my 4 duplexes now, at fair market rate, on a standard lease, and pays it on time every month. Because for the first time in her life, no one is standing behind her ready to absorb the consequence if she doesn't. Last month, she asked me, half joking, half not, whether I'd teach her how to actually read a lease before she signs her next one, instead of just trusting whoever hands it to her. I said yes. We met at my kitchen table, the same table I used to build my file at during those 5 months, and I walked her through every clause the way I would for a client, slowly, patiently, the way nobody had ever once done for either of us when we were young. My father, for his part, has never fully said the sentence my mother eventually managed to say. He apologizes in smaller, sideways ways now, offering to fix something at my house, asking after my work, small gestures that function as apologies without ever quite becoming one out loud. I've stopped waiting for the direct version. Some people only ever learn to say sorry in a language other than words, and at some point, you either learn to read that language or you spend the rest of your life waiting for a sentence that isn't coming. I've chosen, mostly, to read it. Mostly. Here's what I learned, sitting in that lawyer's office 14 days before a deadline my own family had unknowingly built for themselves. Love that only shows up on paper when it's convenient was never love. It was custody of a story that only worked as long as nobody read the actual documents closely enough to challenge it. My family spent 30 years teaching me that blood decides who carries a family forward. What they actually taught me, without meaning to, is that competence decides who's left holding anything real once the story runs out of road. I didn't win anything back from them out of anger. I simply refused to be the only person in that family who didn't understand what was actually written down. Everything else followed from that one refusal, calmly, procedurally, one document at a time. I think there's a version of this story people want, where I storm into that office or that dinner table and finally say all the things I'd swallowed for 30 years, and everyone gasps, and the room changes because of the force of what I said. That's not what actually happened. And I've come to believe it's not actually what justice looks like for people like me. The fixers, the ones who were always trusted with the numbers but never quite trusted with the inheritance. Justice, for us, doesn't usually arrive as a single dramatic sentence. It arrives as a folder. It arrives as a notarized signature from 11 years ago that nobody else remembered still mattered. It arrives quietly, on someone else's clock. And by the time anyone else in the room understands what's happening, it's already been true for years. I also learned something less comfortable, which is that being the responsible one is not the same thing as being the protected one, and no amount of quietly covering shortfalls, co-signing loans, or showing up with tax documents every March will ever retroactively earn you a place at a table that was never actually built to include you. That place has to be built separately, on your own terms, usually with your own money, sometimes. As strange as this is to say out loud, using the exact same legal instruments the people who excluded you assumed would only ever protect them. If you take one thing from this story, let it be that. The tools of exclusion and the tools of justice are frequently the same tools. It's simply a matter of who actually understands how to read them and who's willing to wait long enough to use them. If you've ever been the fixer in your family, the one everyone calls when something's broken, but nobody ever quite lets fully belong, I want you to hear this clearly. You don't have to raise your voice to be taken seriously. You just have to read the paper closer than anyone assumes you will and be patient enough to let it do the talking when the moment finally comes. I still carry my grandfather's pencil. I still tap it 3 times before I open any file that matters. Some habits outlive the reasons you first built them and become something steadier instead. Not a superstition, just a small, private reminder that composure has always been the one inheritance nobody in my family could ever legally take away from me, because it was never listed on anyone's ledger to begin with. It was simply mine, the whole time, whether they wrote my name down or not. If this story meant something to you, tell me in the comments where you're watching from and what your own family's version of Blood Decides sounds like. I read every single one. Share this with someone who's ever been told there was nothing there for them, and make sure you're subscribed, because there's another story just like this one waiting for you next. I'll see you in the next one.